Hello there. Welcome to video 151 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. And do remember to like and share this video too. To make your task a little easier, here is a complete list of all the 151 videos available on my YouTube channel. The list is divided into the playlists under which they are available. Do have a look. In this video, we shall study the Lokpal and the Lokayuktas Act of 2013. This act provides for the establishment of a Lokpal at the union and a Lokayukt at the state level. These statutory bodies perform the function of an ombudsman, that is, conduct inquiries against public officials for allegations regarding corruption. I do hope you know the meaning of the term ombudsman. Well, an ombudsman is an official appointed to investigate individuals' complaints against a company or organization, especially a public authority. Every country faces the menace of corruption, which is prevalent in administrative bodies. There needs to be a mechanism to keep these bodies in check. This act, therefore, is an invaluable tool in the hands of the common man to file complaints of corruption against public authorities. This act is regarded as a landmark move in the political history of India as it establishes a fairly independent body against corruption, which can be accessed easily by all the citizens. Corruption is a phenomena which has plagued innumerable societies and has been detrimental to their progress and development. In 1966, the Government of India had constituted the Administrative Reforms Commission under the chairmanship of Morarji Desai, later taken over by K. Hanumanthayya. The goal of the commission was to lay out guidelines for better governance. It went on to recommend the establishment of the Lok Pal at the center and the Lokayukt at the state level. From 1966 to 2011, 8 different bills were introduced in the Lok Sabha, but they never actually converted into legislation. Owing to the increasing rates of corruption, in the year 2011, Anna Hazare had undertaken a fast until death to demand for a concrete body that would monitor the corruption levels. Following these protests, within 2 years, the Lokpal and the Lokayukt Act of 2013 was enacted. In the meantime, India ratified the United Nations Convention Against Corruption in 2011 and committed itself to pursue the policy of zero tolerance against corruption. It is the only legally binding international anti-corruption multilateral treaty. So, what are the objectives of this Act? The Act undertakes to establish a quasi-judicial body of Lokpal for the Union and Lokayukts for states to inquire into allegations of corruption against public functionaries. It therefore provides for an institution of ombudsman for complaints relating to corruption. And now let us have a look at the salient features of the Act. The Lokpal and the Lokayukt Act of 2013 came into effect on 16th of January 2014. The Act is applicable even to Jammu and Kashmir. The Act sought to set up a Lokpal that would serve as an active vigil and monitor any malpractices of any civil servant or governmental organizations. The setup of Lokpal consists of 8 members, 4 of whom must have some legal background. The chairperson would be the Chief Justice of India or a judge of the Supreme Court. A judicial member shall be someone who is or has been a judge of the Supreme Court or a Chief Justice of a High Court. So, who appoints the Lokpal? A 5-member panel comprising the Prime Minister, the Lok Sabha Speaker, the Leader of the Opposition, the Chief Justice of India, and an eminent jurist nominated by the President selects the Lokpal. The other 50%, that is the other 4 members, shall be persons of outstanding integrity and ability and would be people of special knowledge and experience of not less than 25 years in matters of corruption, public administration, etc. and from the minority spheres of society, for instance, scheduled tribe, scheduled caste, OBC, and women. The Act also provides for certain parameters that have to be followed during the process of appointment of members and the chairperson of the Lokpal. To elucidate, the Act prohibits the appointment of a former convict as the chairperson of the body. The term of office of the chairperson and members shall be 5 years from the date of appointment or until they attain the age of 70 years. As per Section 11 of the Act, an inquiry wing shall be constituted by the Lok Pal and headed by the Director of Inquiry to conduct a preliminary inquiry into any allegation against a public servant, which is punishable under the Prevention of Corruption Act 1988. The Lokpal shall also constitute a prosecution wing under Section 12, which shall be headed by the Director of Prosecution. It shall prosecute public servants concerning complaints under this Act and will file a case in the special court about any offence punishable under the Prevention of Corruption Act. So, what is the jurisdiction of the Lokpal? The Lokpal can inquire into any matter of allegation of corruption against any person who is or has been a Prime Minister, Union Minister, and a member of any of the Houses of Parliament, any government official, any person associated with any corporation or authority, or company or society established by an Act of Parliament. Lokpal can also inquire against any member, director, or manager of any society or association of persons wholly or partly financed by the Government of India, or where such organization receives a donation of rupees 10 lakhs or more from a foreign source under the Foreign Contribution Regulation Act 2010. Section 16 of the Act provides for the constitution of the benches of Lokpal. A bench shall consist of a chairperson with 2 or more members. Every bench is required to have at least 1 judicial member. The bench shall ordinarily sit at New Delhi but can also sit at any other place as notified. The Lokpal shall notify the area of jurisdiction of each bench. Now we come to the procedure of inquiry. Chapter 7 of the Act deals with the procedure of inquiry and investigations in complaints of corruption against any public functionary. Section 20 states that on receipt of a complaint, a preliminary inquiry shall be conducted by the inquiry wing or any agency against a public servant to determine whether there are any prima facie facts for prosecution. The inquiry wing or agency shall also seek comments on the allegations from the government servant and the competent authority, after which it shall submit a report to the Lokpal. Now, this has been done within a period of 60 days from the date when the matter was referred to it. A bench of Lokpal consisting of at least 3 members shall consider the report and will then provide the accused public servant with an opportunity of being heard. If the Lokpal feels that a prima facie case exists, then it can either conduct further investigation through any agency or start a departmental inquiry. Otherwise, it can close the complaint and proceed for prosecution for a false complaint. Section 25 of the Act deals with the supervisory powers of the Lokpal. Now, it has the power of superintendence over the Delhi Special Police Establishment and can give direction for matters referred for inquiry under this Act. It also has powers to authorize the conduct of search and seizure over any place for any relevant documents. The inquiry wing of the Lokpal has been given powers of a civil court under Section 27 of the Act. The most important power of the Lokpal is that of confiscation and attachment of assets of any public servant which it finds is related to an act of corruption. It can also direct transfer or suspension of a public servant if it feels that his appointment may cause prejudice to any inquiry. The central government shall constitute special courts as recommended by the Lokpal to adjudicate cases arising under the Prevention of Corruption Act 1988 or this Act. These courts are required to complete the trial of cases within 1 year from the date of filing. However, an extension of 3 months can be taken up to a maximum of 2 years. But the reasons for such extension are to be recorded in writing. Every public servant is required to make a declaration about his assets and liabilities in the prescribed manner as per Section 44 of this Act. If any public servant fails to declare such assets or provides any misleading information, it shall be deemed that such assets were acquired through corruption. However, a competent authority may condone or exempt a public servant from furnishing information regarding assets not exceeding a certain value. If any person makes a false or vexatious complaint, they shall be liable to a year's imprisonment and a fine up to rupees 1 lakh. The person shall also pay compensation to the public servant against whom the complaint has been made, in addition to the cost of litigation. Now, do remember that civil courts have been barred from exercising jurisdiction over matters that Lokpal is empowered to look into as per the provisions of this Act. Let us now move on to the institution of Lokayuktas. Every state government, through a law drafted by the state legislature, is to establish a body called the Lokayukt for the state to deal with complaints of corruption at the state level against public functionaries. Then came the Lokpal and the Lokayuktas Amendment Act of 2016. After the introduction of the Lokpal and the Lokayuktas Act 2013, a bill was passed by Parliament in July 2016, which amended the Lokpal and the Lokayuktas Act 2013. This amendment enabled the leader of the single largest opposition party in the Lok Sabha to become a member of the selection committee in the absence of a recognized leader of opposition. This bill also amended Section 44 of the Act. Now, Section 44 of the Act dealt with the provisions of furnishing of details of assets and liabilities within 30 days of joining government service of any public servant. Now, this amendment replaced the time limit of 30 days. It stated that the public servants will make a declaration of their assets and liabilities in the form and manner as prescribed by the government. In the case where any non-governmental organization receives funds of more than rupees 1 crore from the government or receives foreign funding of more than rupees 10 lakhs, then the assets of the trustees and board members are to be disclosed to the Lok Pal. The bill provided an extension to the time limit given to the trustees and board members to declare their assets and those of their spouses. So, are there any limitations to the functioning of the Lok Pal? The institution of Lok Pal came up as a much needed change in the battle against corruption. The Lok Pal was a weapon to curtail the corruption that was spreading in the entire administrative structure of India. At the same time, there are loopholes and lacunae which needs to be corrected. The act has become ineffective due to lack of political will and influence of political parties over the Lok Pal. It also fails to provide any immunity to whistleblowers. There is a strict penalty against the complainant if the accused is found innocent, thus discouraging citizens to file complaints against powerful public functionaries. The judiciary too has been kept out of its ambit. There are no criteria to decide who is an eminent jurist or a person of integrity, which manipulates the method of appointment of Lok Pal. The Lok Pal does not have any constitutional backing. There are no adequate provisions for appeal against the actions of the Lok Pal. The states have complete discretion with respect to the specific details in relation to the appointment of the Lokayukt. The Lokpal and the Lokayukt Act also mandates that no complaint against corruption can be registered after a period of 7 years from the date on which the mentioned offence is alleged to have been committed. In conclusion, we may say that in order to tackle the problem of corruption, the institution of ombudsman should be strengthened both in terms of functional autonomy and the availability of manpower. The appointment of Lokpal in itself is certainly not enough. The government should address the issues based on which people are demanding a Lokpal. Merely adding to the strength of investigative agencies will increase the size of the government but not necessarily improve governance. Moreover, Lokpal and Lokayukt must be financially, administratively, and legally independent of those whom they are called upon to investigate and prosecute. Lokpal and Lokayukt appointments must be done transparently so as to minimize the chances of the wrong sort of people getting in. There is a need for a multiplicity of decentralized institutions with appropriate accountability mechanisms to avoid the concentration of too much power in any one institution or authority. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject and not for any financial gain. Do like and share this video and do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.